This concludes my opening statement. I please ask you, Mr. President, to give the floor to Professor Tams.
I thank the agent of Germany for her statement. I now invite Mr. Christian Tams to take the floor. You have the floor.
Mr. President, members of the court, it's an honor to address you and a privilege to do so on behalf of Germany. In my presentation, I will respond to Nicaragua's depiction of Germany as willfully disregarding rights of the Palestinian people and supporting or enabling breaches of international law. Nicaragua's factual claims do not withstand scrutiny. They are based on speculation and at times misrepresentation. To set the record straight, Germany has provided you with a set of core documents in the judges folder. I will refer you to these documents in relatively quick succession, but I will provide key points on the slides. I do so first to rebut Nicaragua's accusation that Germany had turned its back on the Palestinians. On this point, Nicaragua yesterday changed its pleading significantly. It now no longer seems to claim, as it has done in its application, that Germany, and I quote, halted its bilateral financial assistance to the Palestinians without further consideration early in the conflict, end of quote. Instead, Council yesterday acknowledged that Germany, and I quote again, is engaged in facilitating or improving humanitarian aid in Gaza and for its suffering people, end of quote. And we welcome this correction. However, Germany firmly rejects Nicaragua's characterization that this engagement is, and I quote again, a pathetic excuse, as Nicaragua claims. Mr. President, documents contained in Annexes 2 to 5 of the judges folder show how inaccurate this assertion is. Annex 2 brings together a list of statements by high-ranking German representatives, which reflect Germany's commitment to support Palestinians in Gaza from early on in the conflict. Let me take you to the first statement included in the list, made by Foreign Minister Baerbock on 19th October last year. You'll see it on the slide with its two key messages highlighted. One, the appointment of a senior German diplomat, Mrs. Daike-Potzel, as special envoy for Middle East humanitarian issues. You heard nothing about Mrs. Potzel and her work in Nicaragua's pleading yesterday. Nothing about 5 months of tireless humanitarian diplomacy. Nothing about her public and behind-the-scenes engagement to increase the flow of humanitarian assistance under extremely challenging conditions. Also on the slide, a pledge made on 19th October last year. A pledge that Germany, and I quote, stands ready, is prepared to provide comprehensive humanitarian assistance. A pledge on which Germany acted on the same day by allocating an additional 50 million euros in humanitarian assistance for the people in Gaza. Annex 3 gives us a fuller account of Germany's concrete contribution, and the central information is also on the slide. It contains figures from the UN Office for the Coordination of Humanitarian Affairs, OCHA. It lists support for the occupied territories by country. The chart for 2023 lists Germany as the largest international donor. And if you look at the chart for January to 31st March 2024, which is in Annex 4 and now also on the slide, you will see that Germany has remained the largest donor. Mr. President, Germany's total support for Palestine since early 2023 stands at 254.5 million euros in humanitarian assistance alone. Since 7th October 2023, Rather than halting its support, Germany has more than tripled its humanitarian assistance to the Palestinians in the occupied territories. And Annex 5 highlights the real impact of Germany's commitment. I would ask you to consider this as you reflect on Nicaragua's characterization that this is just a pathetic excuse. Mr. President, members of the court, in addition to dismissing Germany's support, yesterday Counsel for Nicaragua accused Germany of having, and I quote, defunded UNRWA, a decision that Nicaragua presents as the cutting off of aid at the most critical moment. This Nicaraguan claim is entirely without merit. Core information about what really happened is in Annex 6 to 9 of your folder. I will limit myself to 3 points. First, Germany has not defunded UNRWA. On 27th January, it took a temporary decision not to approve further funds to UNRWA operations in Gaza. This decision was taken in response to grave allegations that UNRWA staff were implicated in the terror attacks of 7th October. Allegations that left the UN Secretary General horrified and that continue to be investigated. Germany has since resumed its funding for UNRWA operations in the West Bank, Jordan, and elsewhere, committing a further 45 million euros. And already on the 1st of March, the very day Nicaragua instituted proceedings, Germany agreed in consultation with other EU member states to release a 50 million euro emergency assistance package from European Union funds. 12.5 million euros of these funds are provided by Germany. But Nicaragua not only, and this is my second point, ignores this context. It ignores the fact that Germany's temporary decision of 27th January has had no direct effects on UNRWA operations. On 27th January, Germany was not due to release any funds for UNRWA for operations in Gaza that would have been withheld or withdrawn as a result of the decision. And this was made very clear in the statements announcing the decision, which you see on the slide. It includes the phrase, "There are no new funding decisions pending. Humanitarian assistance will continue." Put differently, not a single euro of support has been halted or withdrawn. Quite to the contrary, Germany honors its pledges. Funds provided before 27th January are still being used to support UNRWA work in Gaza. Third, quite apart from UNRWA, Germany has stepped up its support for Gaza. The information contained in Annex 10 of the judge's folder make this abundantly clear. Annex 10 lists relevant actions and decisions taken by Germany since the 27th of January. It is by no means exhaustive, but it shows what has really been happening. I will have to be very selective, but would urge you to look at Annex 10 when you consider Nicaragua's claims. And when you look, you will see that immediately after 27th January 2024, the German government made available support to other humanitarian donors, such as UNICEF, the ICRC, and the World Food Programme. An additional support now amounting to nearly 40 million euros, in addition to funds provided to UNRWA and to contributions via the EU and the regular UN budget. Annex 10 also highlights numerous examples of direct operational support aimed to alleviate the situation in Gaza. In-kind support, such as supplying hundreds of tons of medical and sanitary equipment to the Palestinian Red Crescent in February. Ongoing work behind the scenes to ensure that help provided by agencies actually reaches Gaza under the most difficult conditions. And as an emergency measure, airdrops, an initiative by the Jordanian government in which the German Air Force cooperates. 16 airdrops so far have landed 83 tons of food directly into Gaza, and another one is scheduled for today. it is plainly wrong to suggest that Germany has in any way turned its back on Palestine. Germany works with countless partners through various routes, leaving no stone unturned to alleviate the suffering. Mr. President, members of the court, I turn to the second part of my presentation. Nicaragua accuses Germany of providing Israel with military aid and thereby facilitating breaches of international law. It says relatively little on how this equipment is supposedly used, and I will come back to this matter. Instead, Counsel for Nicaragua repeatedly mentioned the total volume of licensed exports in 2023, 326 million euros, and made references to items allegedly delivered, such as, and I quote, artillery shells and munitions. But the picture presented by Nicaragua is at best inaccurate, and at worst, it is a deliberate misrepresentation of the actual situation. Of course, Germany and Israel have close ties, including in defense cooperation. Germany's responsibility for Israel's security, emphasized by Germany's agent just now in her opening statement, is an important factor in this respect. But this cooperation is based on a robust legal framework that assesses export licensing requests on a case-by-case basis, and that ensures compliance with national law and Germany's international obligations. And if we look at what has actually been licensed for export to Israel under this framework since October 2023, we see no artillery shells, no munitions. Nearly all exports involve what is known as other military equipment, typically of a subordinate or defensive nature. Mr. President, permit me to begin with a comment about the German framework governing exports of military equipment, about which you have heard nothing from Nicaragua. This is a robust framework. All German exports of military technology and equipment to Israel are subject to strict licensing requirements. Among these, German law distinguishes between two categories: war weapons, Kriegswaffen, and other military equipment, sonstige Rüstungsgüter in the original German. War weapons comprise, for example, combat aircraft or tanks, but also automatic weapons and certain corresponding ammunition and essential components. These war weapons require 2 licenses before export, under the War Weapons Control Act and under the Foreign Trade and Payments Act. The other category, other military equipment, is broad. It goes much beyond weaponry in the usual sense. It includes, for example, defense equipment against chemical hazards, protective gear, such as helmets or body protection plates, communication equipment, camouflage paint, and components, parts, and other equipment of a subordinate character. Outside standardized categories for routine deliveries, not only war weapons, but also all other military equipment under German law requires an individual license for export. And such individual license can only be granted following a case-by-case assessment of an individual application on the basis of binding criteria. We have provided in Annex 11 to 18 of the Judges folder relevant excerpts of the applicable German laws, but also of the 2008 EU Council Common Position defining common rules governing control of exports of military technology and equipment, and the Arms Trade Treaty. Professor Peters will take you to these. At this stage, permit me to make a threshold point. For every license that is granted, the German government carefully assesses whether there is a clear risk that the particular item subject to licensing would be used in the commission of genocide, crimes against humanity, or grave breaches of the Geneva Conventions of 1949. This requirement follows from binding rules of German and European law, which exceed international requirements. As Professor Peters and Palchetti will illustrate the scrutiny is detailed, and it involves an interagency process with consideration by at least two ministries, the Federal Ministry for Economic Affairs and Climate Action and the Federal Foreign Office. And depending on the content of the license application, potentially also the Ministry of Defense and the Federal Chancellery, the Federal Ministry for Economic Cooperation and Development, the Federal Ministry of Finance, the Federal Ministry of the Interior and Community, and the Federal Ministry of Justice. As regards these war weapons, licenses must be issued at the ministerial level and accompanied by a corresponding additional license issued by the Federal Office for Economic Affairs and Export Control. Mr. President, what military equipment has Germany licensed? Military exports, of course, are a highly sensitive matter. Nonetheless, Germany has made a sincere effort to provide you with information that allows you to scrutinize Nicaragua's assertions. We have included core figures provided by government departments involved in the licensing process in Annex 19 of the judge's folder. Let me highlight 3 points before commenting on particular accusations that Nicaragua made yesterday. My first comment concerns the central categories of military equipment distinguished under German law, which I've mentioned already. War weapons, including ammunition and essential components on the one hand, and other military equipment on the other. This is an important distinction because the risks associated with the export of war weapons are naturally much higher, which is a central factor in deciding on licenses. Nicaragua was very brief on this distinction. From the slide, you see what Nicaragua omitted. 98% of the licenses granted since 7th October 2023 did not concern war weapons, but other military equipment. In 4 instances only has Germany eventually licensed the export of war weapons since October 2023. And this is the first relevant point of context if we want to appreciate the actual licensing practice. My second point, which also appears from document 19 and on which Nicaragua again was completely silent, concerns this. If we look at the statistics that Nicaragua presented to you, we see that over 25% of the volume of exports were never destined for final use in Israel. Licenses worth around 85 million euros concern military equipment that is to be processed in Israel and then re-imported to Germany, re-imported for use by the German armed forces. Yet this equipment features in the statistic that Nicaragua relies on to make its accusations. And my third point, the temporal context, another crucial factor, as the risks are being assessed not just with respect to particular military goods, but also at a particular point in time, in light of circumstances obtaining then. Nicaragua yesterday sought to make you think that there had been no evolution. Professor Pelé asserted that Germany
continues to authorize large-scale delivery of weapons.
In response, let me ask you to look at the following slide. It shows how the total value of exports for war weapons and for other military equipment to Israel since October 2023 is spread out over the past months. The exact figures again are in Annex 19 of the judge's folder, but the basic point emerges clearly from the slide. Almost 80% of the volume of exports was approved before the end of October 2023 in what this court has referred to as the immediate context of Hamas's horrendous massacres. At that point, and in this dramatic situation, Germany decided to prioritize pending license requests. Following October, the total volume of exports has dropped sharply, and you see the figures on the slide, to 24 million, 19 million, 8.5 million, and so on. For now, permit me to mention 2 salient aspects. The first is this. In February and March 2024, the total volume of exports for war weapons and other military equipment, the volume of exports approved by Germany, was at around 500,000 and around 1 million euros respectively. These licenses were issued for lenses for daylight observation binoculars, bonding devices for hydrogen storage on submarines, and infrared protection systems for defense against guided missiles. The most recent license, and this is my second particular point, was granted on the 8th of March 2024. It concerned a slip ring for the installation in a radar system. This is not an item that could plausibly be used to commit war crimes. A limited number of requests for exports remain under review for the time being. They are reviewed by German authorities in light of the developing situation and of the potential impact that the particular item might have. Mr. President, this brings me to the end of my overview of what exports have actually been licensed since October. Permit me to conclude by responding to three specific accusations that Nicaragua made yesterday. And they concern particularly military items that, according to Nicaragua, Germany has delivered to Israel. But I begin by responding to points raised by Council yesterday, who noted that quite apart from exports of military equipment, Germany had supplied military equipment directly to Israel, government to government, and specifically in that respect mentioned a request for tank ammunition. Mr. President, we have verified this with the German ministry yesterday. Based on the information I received, I can confirm that Israel approached the German government in 2023 for tank ammunition. This application is being scrutinized. No license has been approved. In fact, and this goes to Nicaragua's broader insinuation yesterday, the only items directly supplied from the German Bundeswehr, armed forces, to Israel are sanitary material and helmets. Nicaragua's second specific allegation made yesterday concerns war weapons allegedly licensed for export. Nicaragua yesterday repeated points made in the application, namely that Germany had provided Israel with, I quote, all type of military aid that would be used to commit grave crimes under international law, such as anti-tank weapons, ammunition for machine guns, and propellant charges, end of quote. I have already mentioned that since October 2023, 4 licenses for war weapons have been granted. But Nicaragua completely misrepresents what they covered. 2 of these licenses indeed concerned ammunition, as Nicaragua notes. 500 pieces of ammunition were approved in November, a further 1,000 pieces approved in early 2024, both for industrial cooperation. What Nicaragua does not say is that the license was for training ammunition. Training ammunition that is, as German exports involved in the licensing process confirmed, not suitable for combat operation. The third license concerns propellant charges, again, as Nicaragua notes, also granted in connection with a cooperation project between German and Israeli industry. But again, Nicaragua omits the key bit of information. The propellant charges were for test purposes. Most of the propellant charges licensed for export are to be destroyed in Israel. The rest is to be redelivered to Germany. So to reiterate, 3 of the 4 final export licenses for war weapons concerned items that are unsuitable for use in combat operations. The 4th license, which was in the immediate context of Hamas massacres, concerned the export of 3,000 portable anti-tank weapons. Finally, to complete the picture, let me add in full transparency that for 1 further military item, 1 license has been granted. This is a submarine which has received 1 license, as I mentioned, but as a war weapons requires 2 licenses for export. So 4 war weapons licensed for export, 3 of them for test and training purposes, and 1 submarine not yet approved for export. That is the outcome of the actual licensing practice since October 2023. Nicaragua's references yesterday, referring to artillery shells or to munitions that would be used in Gaza simply bear no relation to reality. Germany rejects them. Mr. President, my final point concerns the Heron drones, unmanned vehicles. They featured prominently in Nicaragua's application as well as in its presentation yesterday. Germany stands accused of having handed over 2 Heron drones to Israel, and Counsel for Nicaragua insisted on the point yesterday, noting, and I quote, that the destruction caused by the unmanned aerial vehicles like these drones had been widely reported, end of quote. Again, Nicaragua's assertions are false. The truth about the Heron drones can be found in the document in Annex 20 of the folder, and the essence is this. The 2 Heron drones are Israeli drones. They are owned by Israel, not Germany. At no point have they left Israel. German soldiers were trained on them while in Israel under a lease agreement, which specified Israeli ownership and control. While German soldiers trained on these drones, the Heron drones were unarmed. After 7th October, German military personnel left Israel as their security could not be guaranteed, and so the training on Israeli soil temporarily ended. This is the context. Nicaragua is again wrong on the basic facts. Mr. President, to sum up, 98% of the licenses granted after 7th October do not concern war weapons, but other military equipment. Over 25% of this military equipment is destined for eventual re-importation and used by the German armed forces. 80% of the volume that was approved for export was approved in October 2023. Applications for export licenses are scrutinized by different ministries by reference to conditions that are more stringent than those under international law. As a matter of fact, only 4 war weapons have been licensed for export since October 2023, 3 of which concern test or practice equipment. Finally, as regards humanitarian assistance, Germany continues to provide humanitarian support every single day under extremely difficult conditions, constructively engaging with international partners. The minute we look closely, Nicaragua's accusations fall apart. This, Mr. President, members of the court, concludes my presentation on the factual background to the present dispute. I'm grateful for your kind attention, and I would ask you now, Mr. President, to invite Mr. Sam Wordsworth to the podium to continue Germany's presentations.
I thank Mr. Towns for his statement. I now invite Mr. Samuel Wordsworth to take the floor. You have the floor, sir.
Mr. President, members of the court, it is a privilege to appear before you and to have been asked by Germany to set out its position that no order on provisional measures can be made given the absence of prima facie jurisdiction and/or a prima facie basis for any exercise of jurisdiction. Germany makes 2 points. First, it is plain from the application, and was no less plain yesterday, that alleged violations of international law by Israel constitute the essential bedrock of Nicaragua's application and request. The Honourable Agent's first speech yesterday was replete with assertions that serious breaches of international humanitarian law and other peremptory norms of international law, including genocide, are taking place in Palestine, alongside references to the genocide committed by Israel. The case on genocide against Germany is entirely dependent upon this, that is, upon a prior finding of breach by Israel. The same applies to Nicaragua's case on international humanitarian law. The agent summarized this claim as follows: the violations of international humanitarian law by Israel create obligations for Germany. I'll return to the details in a moment, but the basic point is that Nicaragua seeks determinations on the conduct of Israel, an absent party, which determinations are a prerequisite to any finding of responsibility on the part of Germany. Yet, Nicaragua must establish that at least prima facie, the court is able to exercise jurisdiction, and it cannot do so given the manifest absence of an indispensable third party, namely Israel. Second, it was said by the agent yesterday that Nicaragua has not had the opportunity to be informed of the position of Germany. Yet the reason for this is Nicaragua's decision to lodge its application without allowing Germany an opportunity to engage and to inform Nicaragua of the basic factual inaccuracies that Professor Tams has just spelt out. Instead, just 17 days after Germany received Nicaragua's note verbal, the current proceedings were commenced without prior warning, relying for the supposed existence of a dispute on a few words by a governmental representative in a general press conference where Germany was seeking to withhold its position because it had then only seen a short press statement from Nicaragua concerning the alleged conduct of 4 states, one of which was Germany. Nicaragua sought to skate over this issue yesterday, but it cannot show even prima facie the existence of the dispute required to establish the court's jurisdiction. Turning to the details, I start with the central need in this case for determinations by the court concerning the conduct of Israel, an absent party. Nicaragua showed itself yesterday to be very sensitive about this, with Professor Pelle seeking to neutralize this key point. First, by saying that at the provisional measures phase, the court is only concerned with the prima facie existence of jurisdiction, not the ability to exercise it, and then by suggesting that the monetary gold line of jurisprudence made no sense. Neither contention is remotely serious. First, at the provisional measures phase, the court will of course examine both the existence of prima facie jurisdiction and the issue of whether prima facie it is able to exercise jurisdiction. No authority was cited to suggest the contrary, and indeed, any different approach would be entirely counterintuitive. The long-standing purpose of provisional measures is to preserve by such measures the rights which may be subsequently adjudged by the court to belong either to the applicant or to the respondent. It makes no difference at all whether the reason for there being no ability to adjudicate on relevant rights is due to absence of jurisdiction or absence of the ability to exercise jurisdiction. Moreover, Nicaragua's contention is flatly inconsistent with the court's established jurisprudence. In the Gambia and Myanmar case, for example, as you can see on your screens, the court was not content simply to establish its jurisdiction prima facie, as it did at paragraph 7 of the order, but it then went on to consider a disputed issue of admissibility, in that case, one of standing. Second, the monetary gold type situation is not wholly exceptional, as was suggested yesterday, and the approach of the court there, or in East Timor, for example, does no more than reflect the basic rule on the essential need for consent. This is to be found in many other contexts, including, for example, maritime delimitation, where the court has held, as one would expect, that it will not rule on an issue when, in order to do so, the rights of a third party that is not before it have to be determined. It is obviously wrong to say that there is no need for such an approach, given Article 59 of the statute and the possibility of intervention, and the current request offers an apt example in this respect. Suppose the court were to make an order in the terms sought by Nicaragua on the basis of the allegedly plausible rights under the Genocide and Geneva Conventions, which presuppose that Israel is in breach of these treaties, or at least that there is a serious risk of such breach. Such a finding would be treated around the world as a generally applicable and objective assessment of actual or likely wrongful conduct by Israel. Yet Israel would have no standing to challenge the order. If Israel wished to see the order amended or lifted, it would have to intervene as a party under Article 62 of the statute. But it could only do so with the consent of both parties, given the absence of a jurisdictional link so far as concerns Nicaragua's claims of breach of IHL. Thus, not only does the claim put forward by Nicaragua seek determinations on the lawfulness of Israel's conduct that will directly impact Israel, it leaves Israel without any avenue to challenge those determinations, save for submission to the court's jurisdiction, with a critical key to even being able to challenge any order held by Nicaragua, given the need for its consent to intervention. Thus, Nicaragua seeks radically to undermine the most fundamental principles concerning consent to jurisdiction. I turn to the further points made by Professor Pele. The first was simply to repeat the contention that the issue of the exercise of jurisdiction does not arise at the provisional measures phase. As he said, there will be no determination on the merits. I say no more on that, other than to recall that issues going to jurisdiction are assessed prima facie by reference to whether the court will be able to make a judgment specifically on the merits, not by looking at the provisional measures phase in isolation. It could not be otherwise. As a second point, it was argued that the current case is one where the legal interests of a third state might be affected, but no more, and hence the principle in monetary gold is not engaged. It was said that no demand was made impacting the rights of a third state, and that the reference point had to be Nicaragua's application, from which it is said to be clear that the issue is not whether Israel has breached its international obligations, but indeed whether Germany has breached its own. While the fundamental rules on consent could not, in any event, be bypassed by attempts at artful pleading, it is useful to focus on Nicaragua's application. This shows that the essential keystone in the construct of the current claim is the unlawful nature in which Israel is said to be pursuing its current military operations in Gaza. This is plain, for example, from paragraphs 8 to 9 of the application, where it is asserted that actions by the Israeli government constituted serious breaches of universally accepted peremptory norms of international law, and that serious violations of international humanitarian law were evident from the start. The responsibility of Germany is alleged, but in complete reliance on asserted wrongful acts of Israel. This can be seen, for example, from paragraph 38 of the application, now on your screen. You can see how this works. The German government has engaged in political, military, and financial support to Israel, despite its awareness that the military operation launched in the OPT, particularly Gaza, was being conducted in complete disregard of international humanitarian law, human rights law, and the Genocide Convention. Then a few lines down, Germany has not acted to bring to an end the wrongful acts of Israel perpetrated against the Palestinians, and has instead supported Israel by providing it with all types of aid, including military aid, that would be used to commit grave crimes under international law. Turning then to the specific declarations sought from the court, at paragraph 67 of the application, Nicaragua first alleges that Germany has breached Article 1 of the Genocide Convention through a failure to prevent genocide. But in order to determine that there has been such a breach, the court must first determine that Israel has committed genocide. This can be seen, for example, from the Bosnian genocide case. And please note that this is a paragraph that Nicaragua put up on the screen yesterday, but omitting the passages underlined on the screen, despite their obvious importance. In particular, a state can be held responsible for breaching the obligation to prevent genocide only if genocide was actually committed. The passage read out by Nicaragua is in italics. The court there emphasizes that it is not saying that there is no obligation of prevention until the perpetration of genocide commences. But the court is clear on the need for a prior finding on genocide before any breach of the obligation to prevent can be determined. And this is reiterated in the second underlined paragraph. If neither genocide nor any of the other acts listed in Article 3 of the Convention are ultimately carried out, then a state that omitted to act when it could have done so cannot be held responsible a posteriori, since the event did not happen, which under the rules set out above must occur for there to be a violation of the obligation to prevent. The same basic point follows from the Croatia and Serbia case. The court found that no genocide had taken place, and hence there could not be any question of responsibility for a failure to prevent genocide, a failure to punish genocide, or complicity in genocide. Turning back to the application, Nicaragua then alleges that Germany has aided and assisted Israel in the commission of genocide and breaches of obligations under international humanitarian law at paragraph 67.3 and 67.2 and 3. And these allegations, again, cannot be determined without a prior determination that the conduct of Israel is unlawful. Article 16 of the ILC Articles on State Responsibility, which the court has considered to be reflective of customary international law, is concerned with aid or assistance in the commission of an internationally wrongful act. There must be an internationally wrongful act. The commentary further clarifies that this must be a completed act. And that, of course, is only confirmed by the subsequent conclusion of the court on complicity in the Croatia and Serbia case that you've just seen. Moreover, the ILC commentary expressly notes, the International Court has repeatedly affirmed that it cannot decide on the international responsibility of a state if in order to do so, it would have to rule as a prerequisite on the lawfulness of the conduct of another state, in the latter's absence and without its consent. This is the so-called monetary gold principle. That principle may well apply to cases under Article 16, since it is of the essence of the responsibility of the aiding or assisting state that the aided or assisted state itself committed, and please note there the use of the past tense, an internationally wrongful act. The commentary does suggest that the monetary gold principle may not be a barrier to judicial proceedings in every case. And indeed, there may, in a given case, already be the requisite prior finding, or indeed the consent from the third state. But in the current case, monetary gold does indeed apply. And I'll return to the case and its application shortly. As to the declarations sought at paragraphs 67.3 and 67.4 of the application for breach of Common Article 1 and related customary international law due to a failure to ensure compliance, a breach of the obligation to ensure respect in all circumstances is necessarily predicated on there having been a lack of the required respect by the other state. The reasoning of the court in the Bosnian genocide case applies equally in the current context. There, as you've seen, the court explained how the state's obligation to prevent and the corresponding duty to act arises when the state learns of the existence of a serious risk of genocide, which is exactly the same as how Nicaragua portrays the operation of Common Article 1. But, as the court also explained, a genocide must occur for there to be a violation of the obligation to prevent. Precisely the same applies here, and it makes no difference at all if Common Article 1 is envisaged as a rule of due diligence, as that is just how the obligation to prevent under the Genocide Convention is interpreted. The basic question remains, how can it be said that there was a failure to ensure respect of a third state if the failure on the part of that third state to respect is not established in the first place? I would add that this is how the court envisaged the operation of this obligation in its 1986 judgment in Nicaragua and USA. And that is also the intuitive result. It is entirely usual for one state to support another in the context of an armed conflict. And this is not an activity that the international community rigidly seeks to deter. It is only if the conduct of the conflict turns out to have been in breach of international humanitarian law that the acts of the state offering support would be expected to be ruled upon. The same basic points apply to paragraph 67.5 of the application, which is predicated on Israel denying Palestine's right to self-determination and maintaining and imposing an apartheid regime. As to the court's jurisprudence, the current case is substantially the same as monetary gold. There, the court explained, the court is not merely called upon to say whether the gold should be delivered to Italy or to the United Kingdom. It is requested to determine first certain legal questions, upon the solution of which depends the delivery of the gold. Or just so here, the court is not merely called upon to pronounce on the state responsibility of Germany. It is required first to make determinations as to the state responsibility of Israel. And Nicaragua cannot avoid this by saying that the court can find breach by Germany on the basis of a serious risk of a breach by Israel. On the correct analysis, such determinations would not be sufficient to establish breach by Germany, as follows from the analogy to the Bosnian genocide case. But anyway, as a matter of principle, it makes no difference whether the required determination is of actual breach or of serious risk of breach, there is still an essential prior determination of the conduct of an absent third state, on which the responsibility of the respondent state wholly depends. The consequent reasoning of the court in Monetary Gold concerning the absence of jurisdiction regarding the underlying issue of breach by Albania thus applies in the current context. In the determination of these questions, questions which relate to the lawful or unlawful character of certain actions of Albania vis-à-vis Italy, only two states, Italy and Albania, are directly interested, or just so here, substituting Israel for Albania and Nicaragua for Italy. To go into the merits of such questions would be to decide a dispute between Italy and Albania. The court cannot decide such a dispute without the consent of Albania. And this is not a case like Nauru, where the determinations with respect to Australia's conduct merely might have had implications for the legal situation of the UK and New Zealand. And the court was in a position to hold that no finding in respect of that legal situation will be needed as a basis for the court's decision on Nauru's claims against Australia. By contrast, the current case is precisely analogous to East Timor, where Portugal's claim as to the unlawfulness of Australia's conduct in entering into the 1989 treaty with Indonesia could not be assessed without first entering into the question why it is that Indonesia could not lawfully have concluded the 1989 treaty. Again, the current case is on all fours. I turn to the existence of a dispute, which is a basic prerequisite to consent to jurisdiction under both Article 9 of the Genocide Convention and Article 36(2) of the Court Statute. The dispute that is relied on must exist objectively at the time the court is seized. Equally well established is the need for a claim of one party that is positively opposed by another, and that the two sides must hold clearly opposite views concerning the question of the performance or non-performance of certain international obligations. As to the basic facts in this case, Nicaragua relies on its press release of 1st February 2024 and a note verbal attaching a letter of 2nd February, as well as the excerpts from a wide-ranging German governmental press conference of 7th February. So Nicaragua says claim plus opposition, hence a dispute. But as the court has explained, the question of whether there is a dispute or not is one of substance, not of form. This is not a box-ticking exercise, as can be seen from the court's very detailed consideration in past cases as to whether there was indeed the required dispute with respect to the asserted source of jurisdiction. And in considering substance, the context is of critical importance. The current parties are at 2 points of remove from the classic bilateral dispute situation. Nicaragua appears in this case only on the basis of alleged erga omnes obligations owed by Germany, which is not, of course, a participant in the ongoing conflict in Gaza. And this is not a case where the parties had already locked horns before the United Nations or in some other fora. In the current situation, for there to be a dispute as a matter of substance, there would have to be some form of meaningful engagement with a claim, pursuant to which Germany communicated its position either to Nicaragua or in such a way that it could objectively be understood as crystallizing a dispute. It was said yesterday that the legal dispute was described in Nicaragua's letter of 2nd February 2024. But this note verbal was sent to the public information email address of Germany's permanent mission to the United Nations in New York, not any address that is used for official diplomatic communications. It was not picked up until the 13th of February, and it should be noted that equivalent note verbal were also sent to the public information email addresses for Canada, the Netherlands, and the United Kingdom. And we understand that these were likewise only picked up on 13th February following a further email sent by Nicaragua to the Netherlands. This approach of Nicaragua is, to say the least, unusual. And indeed, in the past, Nicaragua has always sent note verbal to the appropriate email addresses of the ambassador and assistants at the German embassy in Managua, often copying in other German missions, again, on the appropriate email addresses. It follows that when, at a general press conference of 7th February, a representative of the German Federal Foreign Office was asked questions about having received a note verbal and how Germany intended to respond, Germany was simply not in a position to say anything material. The excerpt of the press release is at Judges folder tab 21, and in due course, I ask you to read this carefully. You will see that the journalist asking the questions correctly understood Germany as not having received any note verbal. And you will also see that Germany did not consider itself ready to make any public statement of its position. This was not and could not have been a response crystallizing a dispute on the basis of a claim in a note verbal that had not been seen. Once it had in fact received the note verbal, Germany was actively considering its response and seeking coordination with the 3 states that had received similar emails when, without warning, Nicaragua commenced the current proceedings on 1st March. There was no opportunity to engage, and it is to be emphasized that this is not a case like Gambia and Myanmar, where the court could infer the existence of a dispute following a failure to respond 1 month following the delivery of a note verbal, but in circumstances where there had already been a number of prior communications, both outside and within the UN General Assembly, that showed the mutual opposition of views. Nicaragua sought to suggest, but was wholly unable to point to, anything remotely equivalent, and notably seeks to invoke the German note verbal of 11th March sent to the court after it was seized. And that, of course, is wholly irrelevant. Of course, the court is only concerned with a prima facie showing, but the fact that this case is at the provisional measures phase cuts both ways. It is not just that extraordinary relief is sought, given that jurisdiction and the ability to exercise jurisdiction have not yet been established. Also, relief is sought on the basis that Germany, a peaceful democratic nation, a long-time avowed supporter of international law and the international legal order, is breaching the Genocide Convention and conventional and customary international law. The determinations sought could scarcely be more serious, and the relief sought also has and is plainly intended to have direct and indirect impacts on third states not before the court. It is precisely in circumstances such as this that jurisdiction prima facie demands a real showing of positive opposition and clearly opposed views, not a precipitate rush to court in the hope that a box might be considered at best half-ticked. Mr. President, members of the court, I thank you for your attention and ask you to call Professor Peters to the floor.
I thank Mr. Wordsworth for his statement. I now invite Ms. Ann Peters to take the floor. You have the floor, madam.
Mr. President, members of the court, it is an honor for me to appear before you and to present Germany's position on plausibility. This court has already been seized in another case to deal with heartbreaking consequences of the armed conflict in Gaza initiated by the brutal attack of Hamas on Israel. But this case is not between the two parties to that armed conflict. Here, this is the first case in the court's history in which provisional measures are sought against a state that stands accused of complicity in and lack of vigilance and prevention of acts of another state that is not party to these proceedings. Both types of legal obligations arise exclusively and necessarily in connection with or in response to the conduct of another state that is absent from these proceedings. Mr. Wordsworth has already demonstrated how this poses a serious admissibility problem. This attempt to request provisional measures against one state by reference to the conduct of another state stretches the plausibility assessment to breaking point in an unprecedented manner. This court will first have to find, on the basis of evidence, that there are plausible facts that establish plausible violations on the part of Israel. Second, the court will have to find that there are plausible facts that establish plausible violations on the part of Germany. Here, the court will especially have to establish whether there are plausible objective and subjective links between the conduct of Germany and the conduct of the absent third state, Israel. In this novel and special constellation, one would have expected Nicaragua to adduce concrete evidence and legal reasoning to substantiate its claims against Germany. However, Nicaragua has said surprisingly little on the law, and as regards the facts, it has almost exclusively relied on speculation and inferences. Nicaragua claims that Germany is complicit in genocide and violations of international humanitarian law allegedly committed by Israel. In paragraph 15 of the application, the applicant mentions German, I quote, involvement in the facilitation of unlawful activities concerning the laws of war. And in paragraph 16, the applicant alleges that Germany is facilitating the commission of genocide and calls this a distinct base of Germany's responsibility. This must fail because the most basic prerequisites for establishing aid and assistance, or what's really the same thing, complicity, are lacking. These prerequisites are a causal contribution of the accomplice to the wrongful act, and knowledge and intention to facilitate the wrongful act of the main perpetrator. Nicaragua has not and cannot provide any evidence to show these elements to be plausible. The standard requirement for causality in law, as applied by international tribunals, is that there must be proximity, directness, or that the breach must not be too remote. Proximity is established where the consequence of an act is a natural and normal consequence. Such a link is especially needed to establish aid and assistance. Aid and assistance must have contributed significantly to the alleged wrongful act. This can only be determined objectively by assessing the quality and the quantity of the real contribution in the concrete case. Nicaragua has offered no evidence as to how any of the military equipment from Germany could have made a significant contribution to an alleged genocide or to breaches of IHL. Given Germany's stringent licensing standards that scrutinize precisely these risks, there is no indication that German equipment would have naturally or normally led to plausible violations of international law by Israel. In addition, Nicaragua has not provided any evidence for the presence of the necessary subjective elements, which are knowledge and intent. In the Bosnian genocide case, you insisted that the conduct of an organ or person furnishing aid or assistance to a perpetrator of the crime of genocide cannot be treated as complicity in genocide unless, at the least, that organ or person acted knowingly, that is to say, in particular, was aware of the specific intent dolo specialis of the principal perpetrator. If that condition is not fulfilled, that is sufficient to exclude the categorization of the conduct as complicity. The position is the same in customary law generally. Aid and assistance must be given with knowledge of the circumstances and with the intention to facilitate the occurrence of the wrongful act. Nicaragua has not provided evidence on any plausible intent on the part of Germany to facilitate internationally wrongful acts. Germany, on the contrary, has demonstrated to this court that its intention has always been to assure full respect of international law, be it the Genocide Convention, international humanitarian law, or other customary law. Germany has engaged with Israel on numerous occasions to urge compliance. As explained by Professor Tams, Germany has a robust legal framework and procedures in place with regard to arms exports. These procedures have been and will continue to be applied. With regard to humanitarian aid, Germany has, contrary to the allegations by Nicaragua, increased its efforts significantly. Given these facts, any allegation of intention to facilitate the perpetration of allegedly wrongful acts by Israel is unfounded. Because the elements of aid and assistance are absent, all claims that Germany has aided and assisted in maintaining a situation resulting from alleged serious breaches of jus cogens by Israel, as Article 41, Section 2 of the Articles on State Responsibility put it, are equally baseless. I now turn to Germany's obligations under Article 1 of the Genocide Convention and Common Article 1 of the Geneva Conventions. Although, generally speaking, obligations to prevent genocide and to ensure respect with IHL are indeed Germany's own obligations. Nevertheless, the emergence of these obligations, the scope, the exact content, and any possible breach of such obligations inevitably depend on, and they also vary by reference to the degree and to the kind of the risk of wrongful acts by another state, in this case, Israel. Allow me to start with the obligation to prevent genocide. That is an obligation of conduct that is incumbent upon all states. Germany is, of course, fully aware of the diverging views over the legal categorization of the Israeli conduct in its defense against the ongoing attack by Hamas. The court has been seized to judge upon this question in another case, not this one. In the current context, it should be noted that Germany has continuously engaged politically with Israel in a dialogue that has not shied away from critical questions. In the strongest terms, German leaders have warned Israel of the grave dangers that a ground offensive in Rafah would pose. For months, in countless meetings, German leaders and diplomats have worked towards the opening of more border crossings. And you've heard Professor Tam state earlier, to prevent famine, Germany is engaged in emergency deliverers dropping food from the air. These concrete measures are at the heart of German policy. So Germany has continuously used all reasonable means at its disposal to both exert its influence on the Israeli partners in order to improve the situation and to itself furnish humanitarian aid. It continues to do so every day. Germany has thus, in any event, duly fulfilled any conceivable obligation to prevent the occurrence of genocide by these concrete measures. We cannot see how any duty to prevent could demand more of Germany. I turn to Common Article 1 of the Geneva Conventions. Leaving aside the fact that Nicaragua as a non-party to the conflict in Gaza, has no standing to enforce Germany's obligations under Common Article 1 with regard to a third state like Israel, a violation of Common Article 1 of the Geneva Conventions by Germany is not plausible. First, in the Nicaragua case of 1986, this court identified one specific external obligation incumbent upon non-parties to an armed conflict: the obligation not to encourage violations of international humanitarian law by another state that finds itself in armed conflict. It is inconceivable that Germany would encourage Israel to violate international humanitarian law. And indeed, not even Nicaragua alleges this. Second, the obligation to ensure respect generates so-called positive obligations to exert one's influence on parties to an armed conflict to observe IHL. Germany has always fulfilled and continues to fulfill this obligation. It is persistently urging Israel to apply restraint, to allow for humanitarian access by opening checkpoints and the like. Ongoing in-depth bilateral exchanges between various ministries on several levels focus on the processes that Israel has in place to ensure respect for international humanitarian law. Yesterday, we heard Nicaragua acknowledge these endeavors. Third, there is the issue of arms export and of export of other military equipment. As I said, Common Article 1 and parallel customary law prohibits states from encouraging violations of IHL. However, this provision does not generate a negative obligation to refrain completely from military support to a state involved in an armed conflict. Common Article 1 does not and cannot block all transfer of aid to a state that might exercise its right to self-defense. Such a blanket prohibition would be nonsensical because it would be incompatible with every state's right to support countries acting in self-defense. While the scope of Common Article 1 is contested and requires further discussion, even taken at its broadest plausible interpretation, the obligation to ensure respect embodied in Common Article 1 can do no more than suggest that all states must conduct a proper risk assessment for decisions regarding exports of military equipment and arms. So assuming that Common Article 1 has implications for the transfer of arms and military equipment, Nicaragua has failed to offer any evidence that plausibly show that Germany did not act in due diligence in its export law and practice. The German legal framework on the manufacturing, marketing, and export of weapons, Kriegswaffen, and other military equipment is four-layered and strict. The German constitution itself, the highest law of the country, monitored by a robust constitutional court, prohibits export of weapons without a license by the federal government. Following these provisions, Germany applies the War Weapons Control Act, its Foreign Trade and Payment Act, the EU Common Position, and the Arms Trade Treaty as binding law. Mr. Tams already explained that at least 4 ministries are involved here, as you also see on the slide. The German federal government's political principles on the export of weapons and other military goods of 2019 explicitly seek to, and I quote the principles, design a restrictive weapons export policy within the framework of Germany's international obligations. These principles are general administrative rules in the sense of the German constitution. With these, the government binds itself and limits its discretion. The principles refer to the EU common position. Further, the export of weapons and military equipment is, to the extent feasible, subject to parliamentary control. The federal government informs Parliament about licensing decisions that have gone through the Federal Security Council and about the kind, number of goods, recipient country, and involved German enterprises. Such reports also cover the total volume of the transactions unless in individual instances constitutionally protected interests prohibit such disclosure. This information is not classified, it's not secret. Allow me to single out only 2 of the relevant benchmarks. All other rules can be found in the judge's folder. Under the EU common position, Germany Having assessed the recipient's country's attitude towards relevant principles established by instruments of international humanitarian law, applies the rule that it shall deny any export license if there is a clear risk that the military technology or equipment to be exported might be used in the commission of serious violations of international humanitarian law, end of quote. Where the German authorities identify such a clear risk, they must deny the export licenses. But please note, the assessment, of course, is by reference to the relevant equipment supplied. If it is a batch of helmets or training ammunition, of course, the assessment may be no risk at all. In the narrower scope of the application of the Arms Trade Treaty, German authorities, I quote, shall not authorize any transfer of conventional arms if they have knowledge at the time of authorization that the arms or items would be used in the commission of genocide, crimes against humanity, grave breaches, attacks directed against civilian objects or other war crimes. If an export is not prohibited under this prohibition, German authorities assess the potential that the item could be used to commit or facilitate a serious violation of IHL. If they find an overriding risk of such a negative consequence, they may not authorize the export. But again, flak jackets might not pose such a risk. Our four-tiered legal and political control regime of exports of arms and military goods is robust. It is democratic, as transparent as possible, given the sensitivity of the material involved. And it is subject to parliamentary and to some extent judicial oversight. Nicaragua has provided no evidence whatsoever that the German licensing policy is not appropriate for conducting the risk prognosis required by international law. By contrast, the German legal framework provides for constant reassessment in the light of highly dynamic situation on the ground. The domestic procedures in place amply satisfy the obligation to ensure respect under Common Article 1. So that any breach is implausible. To conclude, the court must apply a reasonable standard of plausibility that does justice to the special features of this case. The case is brought to this court by a state not party to a conflict against another state that is equally not party to that armed conflict. It requires the application of a stretched plausibility test that operates on two levels. Nicaragua has not provided any evidence for the elements of causality, full knowledge, and intention to facilitate. Germany's conduct is far removed from whatever putative breaches of international law by Israel. All this leads to complicity being out of the question. Germany has fulfilled any potential duty to take proactive steps to prevent any misconduct, including alleged genocide, with its tireless efforts to improve the situation for the people in Gaza. Finally, Germany is employing stringent criteria with respect to a very limited supply of war weaponry. It thus satisfied the due diligence standards under Article 1 of the Genocide Convention, and all the more so its obligation to ensure respect under the broad umbrella clause of Common Article 1 of the Geneva Conventions. Mr. President, members of the court, the situation in Gaza is unbearable. Too many lives have been destroyed. Too many life plans shattered. We all want this to end, but this type of strategic litigation between proxies will not bring us closer to this goal. Mr. President, this concludes my presentation. May I now request the court to call on Professor Paolo Palchetti, who will continue with Germany's presentation. Thank you for your attention.
I thank Ms. Peters for her statement. J'appelle maintenant.
I now call Mr. Paolo Palchetti to the floor. You have the floor, sir. Mr. President, members of the court, it is for me an honor to appear before you on behalf of the Federal Republic of Germany. The court indicates provisional measures if, and I quote you, there is a real and imminent risk of irreparable prejudice concerning the rights claimed. End of quotation. Nicaragua has not demonstrated that Germany's conduct meant that there were any risks to the rights at issue. Its counsel said nothing on that point, which is, however, a crucial one. Above all, they dwelt on the tragic situation that currently prevails in Gaza and on the two orders that you issued in January and March 2024 in the case between South Africa and Israel. Mr. President, there is one thing that must be clear at the outset. Neither of these two orders can be used to demonstrate the existence of an imminent risk attributable to Germany. In your orders, you admittedly acknowledge that the situation in Gaza is such that there is a real and imminent risk for the rights of the Palestinians. But the risk at issue in your orders is that stems from the conduct of Israel. Your conclusion is based solely on consideration being taken of Israel's conduct, whereas what we're dealing with in this case is the conduct of Germany. And it is by referring to Germany's conduct that the existence of any imminent risk has to be established. What your orders state clearly is that the humanitarian situation in the Gaza Strip is catastrophic. Germany is fully aware of that. Its political leaders have declared on numerous occasions that they are distraught in the face of the suffering of the civilian population of Gaza. As a member of the international community, Germany has determinedly done everything it can to make sure that this suffering ceases. It has stressed the need for international law to be complied with, and it has taken concrete measures with a view to responding to international concerns. These measures go to show not only that Nicaragua's contentions in its application are totally baseless, it also shows, and this is what I intend to develop this morning, that there is no imminent risk of harm attributable to Germany. In the time allotted to me, I shall deal first of all with measures pertaining to military assistance, after which I shall move to humanitarian aid. Nicaragua is inviting the court to indicate a measure number 1, asking that Germany, and I quote,
Israel, in particular, its military assistance. Fin de citation.
End of quotation. In its request for the indication of provisional measures, Nicaragua justifies this measure by referring solely to the situation in the Gaza Strip. Yesterday, Nicaragua changed its position. No longer is it talking just about the Gaza Strip, but plausible genocide and other serious violations, I quote, occurring in the Gaza Strip as well as other parts of Palestine, end of quotation. Nicaragua has not explained why this change has occurred. It has not said whether there are any new facts that have emerged that require us to look at the situation prevailing in the Palestinian territory outside Gaza, nor has it provided detailed information on the question. Its strategy is quite simply to throw out accusations without specifying any facts nor providing evidence. It is this same approach that underlies the second measure, which requires of Germany that it must show vigilance as regards weapons that have already been supplied to Israel. Nicaragua, in fact, does not say anything as to how, in practice, Germany could show such vigilance. The agent for Nicaragua yesterday stated, and I quote, that this measure requires Germany to use whatever legal or contractual powers and whatever influence it has over Israel. End of quotation. Mr. President, if it is a matter of exerting any influence over Israel, then Nicaragua can be reassured, as it knows full well the highest authorities of the German state have on numerous occasions urged Israel to agree to a humanitarian pause and to make sure that international humanitarian law is complied with. Any measure from the court along those lines is neither necessary nor urgent. In reality, for the court to indicate measures numbers 1 and 2, Nicaragua would have had to have furnished credible proof demonstrating that there is an imminent risk that Germany intentionally, in full knowledge of the facts or without showing due diligence, is providing military aid to Israel such that it is committing the grave breaches of international law. Nicaragua has not furnished such proof. In fact, it cannot do so, quite simply, and that for an essential reason. German law and German administrative practice subordinate the granting of export licenses for weapons and other military equipment to very severe conditions. Those conditions go far beyond what is required under international law. I have no intention of repeating what has already been said on this matter by Professors Tams and Peters. I will quite simply point out that it is difficult to understand how Nicaragua can state that its current request is urgent, whereas, according to German law, for a long time, very strict conditions have had to be complied with a view to preventing any risk, including that relied on by the applicant state. This is all the more true that the compliance with these strict conditions is something that is monitored throughout the lengthy appraisal procedure prior to the granting of licenses. Let me refer to two main features which demonstrate that there's a very painstaking assessment that is carried out by each. The first of these aspects concerns the number of authorities that are involved in the procedure. As Professors Tams and Peters have pointed out, the license authorizing export of war weapons requires intervention on the part of several ministries, and within each ministry there are experts who prepare a draft opinion as to whether or not the license should be granted. The assessment is finalized by senior ministerial officials. In other words, a license can only be approved if the German government in its entirety, and that means all ministries concerned, agree that the export conditions have been met. The second aspect concerns the object of the verification. First of all, this is to do with the nature of the military material in question, particularly the risk of there being any inappropriate use that might be made thereof. And this is something I would like to stress. There are numerous military articles that come under the heading Other Military Equipment, and the export of which is subject to authorizations according to German legislation, show no risk of there being abusive utilization. That is true of certain articles that are classed as war weapons.
Naturally, the situation of the destination country is also examined very closely. Each request for a license is given to the Foreign Export Service of the Federal Foreign Office, which then draws systematically on the expertise of the specialists of the country in question before giving its opinion. Mr. President, at this point, I should show you how this regime and this procedure have been implemented when having to do with the export of weapons and other military equipment to Israel. However, I don't need to spend any more time on this point since Professor Tams has already shown you the number and content of the licenses which were granted in this context. The framework, however, was sufficiently precise. German law requires that we take into account how the situation on the ground is evolving. These are the guidelines which German authorities and German officials are held to, having to do with Gaza. To convince you that there is an imminent risk of prejudice, Nicaragua is trying to focus your attention on the number of licenses which had been granted by Germany in the weeks immediately following 7 October 2023. Nicaragua claims that the weapons exports to Israel have continued to increase during the following months. Professor Pele said this explicitly, and I quote him, "The sales of arms have not ceased. They have, in fact, increased very considerably," end of quote. This statement distorts reality. Professor Tams has explained to you the real data. You've already seen this graph. The reason I am showing it to you once again is because it very clearly illustrates that Nicaragua's allegations are without merit. What happened is, in fact, the opposite of what Nicaragua spoke about yesterday. I don't need to spend any time on the reasons that led Germany in October of 2023 to reaffirm its commitment to Israel's security. All the more so because the question which needs to interest us here is to establish if there is an imminent risk which could justify the indication of provisional measures. However, we cannot seriously claim to rely on the situation existing in October of 2023 to prove the existence of such a risk. What is more, by ignoring Germany's conduct since October, this risk can be established only based on the situation as it exists today in April 2024. And let me just say, once again, the situation today is clear. German law has imposed strict conditions on weapons exports. This law is continued to be applied and will continue to be applied rigorously by German authorities and officials, including when these exports have to do with Israel. In its case law, the court has already taken into account the guarantees of internal law to exclude the existence of an imminent risk of prejudice. In this case, the court may trust both German law and the continued practice of those officials who are charged with applying it. The conditions that are very strict and which should suffice to prevent the risk of prejudice to the rights that have been cited in this case. So let me come to humanitarian aid now. Provisional Measure 3, requested by Nicaragua, says Germany must resume its support and financing of UNRWA in respect to its operations in Gaza, end of quote. Germany, and this is Nicaragua's argument, by suspending its financing to UNRWA will cause imminent risk of prejudice to the rights of Palestinians in Gaza. The accusation brought by Nicaragua is fully without basis and of bad faith. Germany has not violated any obligation and has not created through its conduct any imminent risk of irreparable prejudice. And let me give you 3 points to prove this. First of all, you've already heard this morning of the varied efforts furnished by Germany in giving humanitarian aid. As Professor Tams has shown, this aid has never stopped, it was not interrupted, and it is continuing actively today. Germany has never shown the intention of stopping that aid. This circumstance is in itself sufficient to be convinced of the absence of an imminent risk attributable to Germany. Nicaragua is avoiding taking into account these initiatives. It is focusing only on the suspension of contributions to UNRWA. It is obvious, however, that the financing of UNRWA is not the only possible form of humanitarian aid. A state cannot be held responsible for an immediate risk of prejudice if it is furnishing and providing humanitarian aid to the population by other means. Number two, so my second observation is that Nicaragua is basing itself on an erroneous assumption. It is not because of the lack of financing that humanitarian aid is not arriving to the population of Palestine. The true problem is that there are restrictions to the entry and distribution of this humanitarian aid. As you've recognized yourself, there is an urgent need to increase the capacity and number of open land crossing points into Gaza. In these circumstances, it is useless to focus on the suspension of our financing of UNRWA. It is clear also that if there are restrictions to entry and distribution of humanitarian aid that may cause the imminent risk to the rights of the Palestinians in Gaza, this risk is not attributable to Germany, which has never had any control over the territory and which has urged many times, including at the highest levels, the officials of Israel, that they need to facilitate the entry of humanitarian aid. My third observation, my last observation, concerns the position of Germany towards UNRWA. Even if we accept to concentrate specifically on the decision to suspend our financing, this is not sufficient to conclude that there is an imminent risk of prejudice. First of all, the decision to provisionally suspend financing for UNRWA had no immediate effect on UNRWA's activity. In fact, according to the pre-established finance plan, no new financing should have been made by Germany in the weeks following January 27, 2024. Secondly, being aware of how necessary it is to get clarity on the grave allegations that have been made against some members of UNRWA staff, Germany has continued to recognize the important role that the agency is playing in Gaza. And this is shown by Germany's support to the initiatives that are financing the work of the organization, including the support for the contribution on 1 March 2024 of 50 million euros by the EU, where Germany is the largest financial contributor. Thirdly, despite the difficulties that the suspension of financing could have created for the organization, there is no immediate risk that UNRWA will stop its activities in Gaza. The Commissioner General of UNRWA, Philippe Lazzarini, recognized at the end of March that the organization has enough financing to continue functioning until the end of May. Moreover, some states have decided to resume their financing. Germany has itself announced financing of 45 million euros for UNRWA's regional work in Jordan, Lebanon, Syria, and the West Bank. So now I come to my conclusions. For the court to indicate provisional measures, there must be a real and imminent risk of irreparable prejudice, and this risk must be evaluated with respect to Germany's conduct. Without this, nothing justifies these measures, neither in the area of military assistance nor in the area of humanitarian aid. Therefore, the court must refuse to indicate the measures which were requested by Nicaragua. Mr. President, members of the court, I thank you for your attention, and I ask you, Mr. President, to give the floor to the agent of Germany, Madam Tania von Uslar-Gleichen. Thank you, Mr. Palchetti, for your statement.
Back to the agent of Germany, Ms. Tania von Uslar-Gleichen. You have the floor, madam.
Thank you. Mr. President, members of the court, in concluding this morning's presentation, permit me to reiterate Germany's grave concern for the situation of the Palestinians in Gaza, that concern it shares with Nicaragua and with this court. To alleviate the suffering of the Palestinians, alongside ensuring the release of the hostages and security for Israel, are central goals of Germany in the current crisis. Our presentations this morning have highlighted what this currently involves. Continuous and close engagement with Israeli and Palestinian leaders in order to increase humanitarian access to Gaza and provide essential humanitarian aid, in order to ensure the adherence to international law, in order to promote a sustainable political solution for peace and security in the region. Mr. President, Germany attaches great importance to the sound and consistent administration of justice by this court. Such administration requires a careful analysis of the evidence and a serious scrutiny of legal claims and respect of the fundamental principles of international law. This is especially so when a case is rushed to this court against a state that is accused of being in an accessory role in alleged violations. As Germany's councils have set out, Nicaragua's request has no basis in law or fact. There are no legal reasons to justify the requested provisional measures. Germany has neither violated the Genocide Convention nor international humanitarian law, neither directly nor indirectly. Our actions, where we support Israel and where we assist Palestine, fulfill our legal obligations and will continue to do so, mindful of changing conditions on the ground. We have done our utmost to see to it that in the Gaza conflict, to which we ourselves are not a party, the rights and obligations of all sides are brought to bear and are being respected. It is the privilege and the burden of politics to try to best possibly balance the legitimate interests of both the Israeli and the Palestinian peoples within the framework of international law. We stand by Israel's right to security and to self-defense, while insisting upon its limits being scrupulously respected. We've done our utmost to use our political leverage to ensure respect for international humanitarian law. We continue to do our utmost to respect our own responsibilities deriving from international humanitarian law and the Genocide Convention. We've done our utmost and more than many to provide humanitarian assistance to the Palestinian people in Gaza, and we continue to work for a political solution too, by the way of a negotiated two-state solution. Mr. President, members of the court, this great hall of justice is not the place for slogans, but for a thorough administration of international justice. With the utmost respect to the court, Germany is confident that the court, guided by these considerations and applying the standards developed in its jurisprudence, will dismiss Nicaragua's request for provisional measures. Against this background, I now proceed to read Germany's final submissions. The Federal Republic of Germany asks the court, first, to reject the request for the indication of provisional measures submitted by the Republic of Nicaragua, and second, to remove from the general list the case introduced by the Republic of Nicaragua on 1st March 2024. This concludes Germany's oral presentation. On the behalf of our delegation, I'm grateful for your kind attention. I would also like to express my gratitude to the Office of the Registrar and to the interpreters for their work during these proceedings. Thank you.
I thank the agent of Germany, whose statement concludes the oral proceedings on the request for the indication of provisional measures submitted by Nicaragua in the case concerning alleged breaches of certain international obligations in respect of the occupied Palestinian territory, Nicaragua versus Germany. I thank the applicants and respondents' agents, counsel and advocates for their oral argument. In accordance with the usual practice, I would ask that the agents remain at the court's disposal to provide any further information it may require. The court will render its order on the request for the indication of provisional measures as soon as possible. The date on which this order will be delivered at a public sitting of the court will be duly communicated to the agents of the parties. Since the court has no other business before it today, the sitting is closed.